Hello and welcome to today's AAHAM webinar, MBA Failures. I'd like to introduce your speakers for today. Lori Lipocky, President, Complex Claims, and Kyle Fischer, General Counsel of Aspirion. Lori and Kyle, if you're ready, the floor is all yours.
Thank you. We want to thank everyone for joining us this afternoon. And so as we get started going over this information today, we're going to give you just a quick info on our background and on Aspirion, and then Kyle's going to start us off by walking you through kind of the accident settlement process. And then we're going to cover the benefits of having a focus on MBA and TPL collections in your revenue cycle. And then, we want to just kind of give you some information about the most common mistakes that we come across in these TPL programs. And then we're going to finish off with Kyle providing you some updates about what we're seeing in terms of litigation trends and class action risks across the nation. So, MBA is very state specific, so we've tried to cover the basics, but we do want you to keep in mind that how these claims are handled will vary a little bit from state to state. And we're going to try to leave some time for questions at the end, but if we do run out of time, our contact information is on the last slide, and so we're happy if you want to reach out to Kyle or myself via email. We'll be happy to try and answer your question. So just a little bit about my background. I worked for Allstate Insurance as a casualty claims manager for about 16 years, and then when we relocated to Georgia and I had to leave my job with Allstate, I got certified to do civil mediations for the Third Judicial Circuit and went to work part-time for a law firm that did corporate work comp, domestic defense, and personal injury law. Kyle was a military attorney with the Army JAG Corps and trial counsel for Martin Army Military Hospital and has done various types of law in private practice. So between the two of us, we have been on all sides of the liability settlement process, including that of the medical provider as we've been providing these services over the years. So, and that is actually how how Aspirion started. A local health system here in Columbus had reached out to our law firm looking for assistance with their MBA claims. And so we worked with their VP of Revenue Cycle to kind of come up with a program that combined, what we knew from the legal aspect as a law firm and my property and casualty knowledge and what they wanted to see from the provider side. And to see how we could come up with a program to apply to the claims in the revenue cycle. And we were able to really make a big improvement in their collections. We took them from about an average of, they were averaging between $8,000 and $9,000 a month. After about 12 months, we were averaging about almost $350,000 per month. So just through that, we started to grow customers through word of mouth over the years. And we've also kind of expanded some services, but we do remain focused in the complex claim piece of the revenue cycle. Claims that need legal support or specialized knowledge, that's probably 10% of your revenue cycle, kind of the hard, messy stuff. And we do provide these services to hospitals in almost all 50 states. We have a few states where we don't have representation, but we do cover most of the country with our services. But, MBA is where we kind of cut our teeth. That's where we started. So, and that is the section of the company of Aspirion that I'm responsible for, and kind of it's always been near and dear to my heart. So to begin with, I think Kyle is going to walk you through kind of what happens after an accident and the settlement process kind of coming from the attorney side.
So every aspect of our business, it all starts off with typically an automobile accident or a situation where the patient is injured due to the negligence of another person. They're taken by ambulance oftentimes to the hospital's ER where they present, and the patient access personnel determine if they have health insurance, either commercial health insurance or governmental pay, or if they're self-pay. If they're self-pay, then if they're injured in an MVA, then motor vehicle accident, then they need to consider whether or not to file a hospital lien. On the patient side, once the patient is treating, typically they will call a personal injury attorney who will begin their work. They'll write letters to the to the at-fault party's insurance carrier asking for the limits, because the attorney wants to know how much money is out there, because a lot of times the attorney's fees are contingent upon getting a settlement and is usually a proportionate share of that settlement, typically between 33 and 40% of what the attorney gets for the patient. The attorney will also send a letter to all the patient's medical providers requesting both the records as well as the bills. The records to show the injuries that the patient suffered, and then that would go towards showing pain and suffering, as well as the bills, because they're going to take the hospital's bills and ask the insurance company if there is enough coverage to pay those bills. There could also be wage loss as well, and they'll look for employment records in that regard. Once the attorney has compiled all this information, then the attorney will send a demand to the at-fault party's insurance carrier, requesting that the insurance carrier provide or pay all their limits of their insured coverage or a sum certain. And then at some point, the personal injury attorney is going to get that check, and then they're going to call the patient into their office, and they're going to take their 33% for attorney's fees, and they're going to ask the patient, okay, do you want me to negotiate your medical bills, or would you just like the remaining balance and you can pay the medical bills? So who do you think the patient, which choice do you think that the patient wants to make? Do you think that they want to make sure that the hospital gets paid, or do you think that the patient wants the money so they can buy a boat? I will tell you the hospital oftentimes are left out in the cold, and that is why we have a hospital lien statute. So let's generally talk about hospital liens. What is a hospital lien? A hospital lien is a legal filing that secures payment of medical bills from a liability settlement. Another way to put it, as the Georgia Supreme Court Justice Melton stated in a case, the purpose of a hospital lien statute is to allow the hospital to step into the shoes of the patient so that the hospital can receive payment for the medical bills from the patient's liability settlement. And why do you file it? Well, as my example shows, it is the only way that you can legally enforce payment of the hospital's medical bills. If you don't get it from the insurance company, you're going to have to go against, file a lawsuit against the patient. That's bad optics, and your chances of getting paid through a judgment and collect on that judgment is very low. When should the hospital lien be filed? Well, if the patient is uninsured, then you definitely should be looking to pursue a hospital lien. If the patient has Medicare, Medicaid, or payer of last resort, and this is depending on the state. We'll talk about Colorado and their lien statute further on down the road. But if they're a payer of last resort, then you should probably look to file a lien. Or if the patient has a high patient responsibility balance after insurance. The lien should be filed as quickly as possible. A lot of times with these lien statutes, you have a certain time period to file it, but you want to file it as quickly as possible because the patient might have other competing medical provider liens, and you want to be first in line so you get paid first in time, or first in time so you get paid, you be first in line for payment. How much recovery can be expected? It really depends on the factors of the settlement. Sometimes you might, for instance, California might be in a state where the minimal limit is $15,000 on an auto carrier's liability insurance, and there's a limitation on how much you can get. Most states have $25,000 per patient or per person injured, and $50,000 per accident. We can expect to get between 70% to 80% of the total bill charges in a lot of the markets where we do business, and that's going to be higher than your certainly higher than your governmental payers, and probably higher than your what you would collect from self-pay. If the lien is not honored, then a lot of times you have to either the patient's attorney will file an interpleader action, pay those settlement proceeds into the court, and say, Your Honor, we have to receive a ruling from you, you have to distribute these funds because they're in dispute, and when we're going to argue why the hospital shouldn't get paid what they're asking. And you have about 6 to 12 months to pursue recovery. This is called the statute of limitations. 6 to 12 months after the settlement to either sue the auto carrier. Now, if your state doesn't have a hospital lien statute, you can explore other remedies. For instance, Ohio law says that letters of protection are enforceable. You might have a security assignment. You want to look at your assignment of benefits language, patient intake, look for directions to pay, assignment of third-party liability benefits. For instance, Virginia has a very specific statute with very specific language that permits the third-party liability carrier to pay the hospital bills directly from the settlement without facing any kind of issues from the patient. And you certainly always want to bill third-party liability coverage.
Okay. All right. Thanks, Kyle. I know just when we look at the settlement process and some of the requirements for filing a lien or for other methods from TPL collections, I know sometimes it sounds a little complicated and you wonder, well, why should we even bother? But, we feel that a good MBA TPL program can benefit both the provider and the patient. And so as benefits to the provider, of course, the main reason that you're focused on having a process in place to help you identify and collect from these payers is that increased cash collection. There are higher collection rates associated with the medical coverage or the liability coverage on an automobile policy than you typically see from self-pay or from your governmental payers. Sometimes they're higher than even some of your commercial insurance rates. We often see, especially in states where the medical coverage on an automobile policy is not mandatory, you can quite often collect up to 100% of the total billed charges depending on the amount of the coverage available. When we average this out across the country, we'll see anywhere from, it ranges from 54.8 to 60% on the medical payments collection. So this is the collection compared to the total billed charge. And then for third-party liability, the collection rate runs a little bit higher. So when you're comparing that to at least, and especially the self-pay rate of recovery, which I think the last data I saw, it was running around 6 or 7% nationally, it can make a big difference. And at least it's getting you paid for those services that you're providing through your emergency room, which is one of your more expensive resources in the hospital setting. I mentioned, the hospital system that got us started into this business and that the increase that they received going from about $8,000 a month to about $348,000 per month on average. So there's definitely an increase in the cash collections for those medical providers who have a lot of these type of claims in their revenue, and that they have a process in place to try to investigate and identify these payers. There's also an impact from having a program that is identifying these payers because you want to make sure that you're coordinating benefits appropriately. I know a lot of health insurance, commercial health insurance contracts will make automobile medical insurance primary. And if you're in a market where that's an optional coverage for your patients, and a lot of times they don't know if they have it or not, you may try to build a claim to Blue Cross or to United Healthcare when they see that it's related to a motor vehicle accident. They won't deny it, but they'll withhold payment, and they want to know if the patient had automobile medical coverage because that would be primary to their insurance. So having a program where you're kind of identifying that up front can also impact your collections from those other payers. And then we know that Medicare does require that you bill medical payments coverage and liability coverages before you try to pursue for your conditional payment through Medicare. As far as benefits to the patient, we believe that there is a way that you can kind of enhance the patient experience at your facility because you want to, patients don't really understand this process themselves. A lot of them don't know if they have the coverage on the policy or not. Most of them have never been in a car accident before, so they really don't know what's supposed to happen. So when they're coming into your facility, they've just been in an accident, they're upset, they're in pain, they're worried. you know, we feel very strongly in our programs that it all starts up front, like with every other claim in your revenue cycle, and that's it, starting with patient access. So you really want to make sure that you're giving your patient access staff, you know, some information about how this process works in your particular state, so they know what questions to ask the patient, so they can explain to the patient, you know, maybe how medical coverage would coordinate with health insurance, you know, just the basics there. And that will be beneficial to the patient, especially, you know, a lot of times when these claims are investigated, you're identifying a way to pay this bill that does not come out of their pocket. It could be coverage that they have on their own automobile policy that they may not have even known that they had available to them. They could be riding in a friend's car, and that friend happens to have this medical coverage on their own policy, and it's going to extend and cover that patient who's riding as a passenger in that vehicle. Or it could be a situation where, you know, you are looking at a third-party liability situation where someone else is at fault. So, you know, we think that this definitely can help the patients if you have a good understanding of what the motor vehicle related laws are in your particular area. We also feel that a hospital lien, while everyone has a pretty negative connotation when you talk about filing a lien, we actually talk to a lot of hospitals that they don't want to file liens on claims in the revenue cycle. And we understand that, you know, on the surface it can look like a very, difficult or negative process. But, you know, one thing to keep in mind is that when we're filing these liens, they only attach the potential settlement, not a patient's assets, not their home, not their bank account. It really only attaches that settlement. That settlement, as Kyle explained, is going to be based on the medical expenses, are one of the key elements in determining the value of that settlement. So those medical bills are typically going to be included in the amount of the settlement. So, you know, the lien is only going to attach that part of that settlement proceed. The other advantage to the patient is, you know, and we explained to them that, look, this will allow us, we're going to file this lien, it'll let us put your account on hold, so you're not going to get collection calls, it's not going to adversely affect your credit, and we'll give you a reasonable amount of time to settle your claim against the at-fault party, and then your medical bills can be taken care of at that time. So that's really how we approach the lien process, and we do feel that when you approach it that way, it is oftentimes viewed as a benefit for the patient. But we know that it's not always easy to set up a good program for MDA and TPL collections. You do need some specialized knowledge both on how these different coverages on automobile policies work. You need to understand your state-specific legal requirements and processes. A lot of times you're going to need legal support. And sometimes, you know, if you have a general counsel there in your hospital system, they may be able to provide some of that. It really just depends on your own situation, because you're going to need to create your lien document, something that's, you know, in compliance with what your lien statute says. Or maybe it's a letter of protection document if you're in a state that you don't have a hospital lien statute. You're also going to want, you know, you may be in a state where an attorney has to sign the lien, or maybe someone on your hospital staff can sign it themselves. There could be some legal actions that become necessary. You know, if you're really going to have an effective lien process, you do need to be prepared, especially in the beginning, to enforce those liens if you know, personal injury attorneys in your area ignore them and overpay them. And sometimes if you can't reach a negotiation agreement, you may be at impasse and you may have an interpleader filed with the court. So you do need some legal resources or legal support to have a really solid program. And then the other issue are the costs associated. This is very labor intensive in terms of having the FTEs available that can do the investigation, that know how to manage the paperwork. A lot of times filing the claims with the automobile carriers for the medical coverage. In some states, it's an electronic process, but for a lot of these other states, it's still a manual paper claim submission. You will have attorneys that are going to want to negotiate the bills with someone, so there needs to be someone that's ready to take on that responsibility. And you do need to have follow-up, regular follow-up. We're going to talk about that a little bit later, about the need to have that, you know, associated with your program. You also have costs for accident reports, filing fees for liens, and then the other legal costs. The other challenge is that there is a trade-off between the aging and the collections. So if you're filing with medical payments or PIP coverage, you're probably going to get a pretty quick return on that. Most statutes in most states require that they pay those claims, usually within 60 days of receiving a clean claim. Most automobile payers will pay them a little faster. But when you're filing a lien against the settlement, that settlement process can be lengthy. I think we average, depending on the market, it's anywhere from 280 days to about 300 days on an average settlement, and that means some of them are going to be a lot faster and some of them are going to age longer. If the case is disputed and it's in litigation, you could be looking at a couple of years. So you are trading that high reimbursement potential for a longer aging on these accounts in your revenue cycle. And then there's the risk. If you're not managing this effectively and you don't have, whether you're doing it yourself or you're using a vendor partner to handle this for you, you really want to make sure that they're monitoring what's going on, not only in your own state, but across the nation, and that you're not doing things that are going to get you into trouble and end you up in some type of class action litigation. So from that, I want to go into the 5 most common mistakes that we recommend that you try to avoid, or these are the mistakes that we see most often whenever we're implementing or whenever we're consulting with the hospital that's trying to improve their program for MBA and TPL collections. And I think as we walk through some of these, I'll be providing you some other information that hopefully you'll find to be helpful. But the number one that we run into is that you're only focused on that liability coverage. And for a lot of hospitals or vendors, they look at this as that if you can go out and file a hospital lien, it's kind of a legal process. You create the document, you file it with the court, and then you can kind of sit back and wait. It's kind of like planting a garden. You plant the seeds and hopefully you reap a harvest on down the road. Well, we feel that liability coverage is not the only source of payment available for accident-related medical expenses, and quite often it's not going to be your best choice. So we're going to spend a few extra minutes on automobile insurance because this is probably the one that you have most often in your revenue cycle. These motor vehicle accidents are a little easier for you to identify. And as I said, that's probably what you're going to have the most volume coming in the door for. I'll touch real quickly at the end on some other collection opportunities associated for other types of accidents. But for the automobile insurance claims, the first place that we recommend that you look is into those medical coverages that may be available. And it doesn't really matter. You may be in a no-fault state where the coverage is mandatory, or you may be in a state where it's not mandatory. But even if you're in one of those states, you're still going to have an option of buying this coverage if you're a consumer and you're purchasing automobile insurance. So this coverage does exist in every state, whether it's required by law or not. So there are basically 2 types that you deal with. We call these no-fault medical coverages because they're not fault-based. It doesn't matter who was at fault for the accident. Not only does it not matter, you can't use the fact that you use this medical coverage as on your automobile insurance. Your automobile insurer cannot use this as a reason to raise your premiums or surcharge your policy. If you're at fault, your policy is going to probably be surcharged anyway, but using the medical coverage doesn't really have any impact on whether you have a change in insurance costs. These coverages are often primary to other health insurance. They do have a high reimbursement rate up to the limit of coverage. In most of your states where the coverage is optional, there is no fee schedule. So they're going to pay what they deem as reasonable and customary, and quite often it's going to be your total bill charge. You can have more than one policy apply, especially when you're talking about the medical payments coverage. I mentioned if you have a patient who's riding with someone else, with a friend, it's always the vehicle that the patient is in that pays first. And then if that's not their own vehicle or a vehicle in their household, it could be their own insurance could then come in and pay as secondary if the bill is there's still an amount of the bill outstanding after that first policy pays. They do pay fairly quickly, as I mentioned earlier. And the other thing about these coverages is that you do want to expand your definition of what is considered a motor vehicle related injury, because it's not just a car accident, but also an injury that occurs while a patient's getting into or out of a vehicle, loading or unloading a vehicle, maintaining a vehicle. any of those injuries that occur while doing any of those activities are covered under these medical coverages on automobile policies. So we do really recommend that everyone kind of, train patient access to expand the definition of what should be registered as motor vehicle related. The other coverage that you may deal with in your state is going to be the personal injury protection. We call it PIP coverage. This is typically the coverage that's required when insurance is mandatory. So if you're in a no-fault state like Florida, New Jersey, New York, Michigan, you most likely are going to have mandatory PIP coverage there. The difference between medical payments coverage and PIP coverage is that the PIP coverage also pays wage loss. It is a little bit more restrictive in terms of, covering under other people that may be guests in the vehicle. And if the patient is out of state, they must be traveling in their vehicle that's registered in the state that requires the no-fault coverage. So it is a little more limited in terms of how you can combine policies together. But both are good sources of recovery. And as I mentioned, quite often they're going to be primary to other health insurance, and so they need to be coordinated that way to be effective on both collections. Now, when there is no medical coverage available on the automobile policy, or maybe there wasn't enough to cover the entire bill, then we recommend you look at the liability situation. Is there with someone else at fault other than the patient? Does the patient have the ability to make a liability claim? Are they telling you that someone else is responsible and they want that other person to pay? So when you're looking at liability insurance, you basically have two types that we run into. You have just the liability insurance, and you call it third-party liability because it's something that you pay for, but it's going to benefit a third party if you were the one that caused the accident. It is mandatory in most states. The minimum limits vary. I think the lowest minimum limit is $15,000 per person. Most states we see have $25,000 as the minimum limit, and it could be on up to $350,000, or even you could have $1 million in coverage. Commercial vehicles typically have a much higher limit of liability insurance. You do have that higher reimbursement rate. The difficulty for liability coverage is you do have to wait for the settlement process to occur. And then you do have to have either a lien or letter protection or something in place to really make sure that you're going to receive some type of payment out of the settlement process. And typically, a lot of attorneys are going to want to try to negotiate what you recover through that process. Uninsured and underinsured motorists is just another form of liability coverage. Usually this comes into play when the at-fault driver either did not have insurance or maybe he didn't have enough insurance to really pay the value of the claim. So I like to give this little example here as a way to kind of tie this together and to show the benefit of looking for that medical coverage before you just automatically look for liability coverage. This is actually a claim that we handled as part of the law firm because one of our attorneys was related to the families involved. And this is a real situation that occurred in Lee County, Alabama. I don't know if anyone on the phone is a graduate of Auburn University, but Auburn is located in Lee County, Alabama. And this home was located in a more rural part of the county. So what you have there in the middle, you have the home, and you have the, a couple that had raised two daughters who grew up, got married, moved out, and had their own families. And so there on the right, the daughter had three boys, and she ended up getting divorced. And divorces are very difficult financially for the people. You're trying to take the assets of one household and now support two different households. She was struggling financially. She was trying to work, and she was paying for after-school care for her children. So her parents said, why don't you and the boys move in with us? That way, Grandma can spend time with them when they get off the school bus in the afternoons. You won't have to pay for after-school care. It'll help you out financially. We'll get to spend more time with the grandkids. It'll be great. So they moved in. She and the three boys moved in with her parents. I think they told us it lasted a couple of weeks, and they realized the house was not big enough for three young boys. So Dad bought a mobile home, put it there in the side yard. She and the three boys moved in there. She ended up getting married again, so that's her new husband there, the stepfather to the three boys. He had a pretty good deal there, no rent, built-in babysitting, so he just moved in and they continued to live there. On the other side, her younger sister, kind of the same thing happened. She ended up getting a divorce. And, you know, those of us that are parents, we know we try to treat our children all the same, love them, you know, equally. So at least this time they knew not to even have them move into the house. Dad just went and bought another mobile home, set it up in the yard. She and the two boys moved in. You'll notice that there's one mailbox. So that's important because this is still considered one residence for legal purposes. So all 5 of these boys were very close in age, and they were all on the same school bus when there was a really serious school bus accident in Lee County. This was back in 2006. It made all the local, you know, news stations, all their evening news stories. There were a lot of injuries involved. Fortunately, there were no fatalities. I know the driver of the school bus and the driver of the other truck were both injured pretty seriously. And probably about 35 kids on the school bus were taken for treatment. They took them to a lot of area hospitals around the Opelika, Auburn, Montgomery, even Birmingham areas. So all 5 of these children had injuries, and there was no health insurance. So when they reached out to the attorney that worked at our firm for some assistance, you know, we went out to meet with them, and the first thing we wanted to look into was to see what coverage was going to be available, either to pay their medical bills and also for liability purposes. So as we interviewed all the family members, we were trying to find out if they had medical coverage on their automobile policy. So first we checked with the older sister, the one with the 3 boys, and she did not have medical coverage on her policy. We checked with the younger sister. She didn't either. We also checked with the parents, you know, the grandparents of the 5 boys, and they did not carry medical coverage on their policy because in Alabama it's an optional coverage. Probably 4 out of 10 drivers will have this coverage on their policy. So we did ask, well, is there anyone else that lives here that has a vehicle that has insurance? So I don't know if you can see on your slide there, but in the trailer on the right in the window, that's the new husband's brother who had moved down about 3 months before. So he's the step uncle to these 5 boys. And so he had lost his job up north and had moved down and moved in with his brother and had gone to work with his brother at his place of business. And so he was living there with the family. He's considered a resident relative under, in terms of the insurance policy. And so he gave us his insurance information. His truck was insured with Progressive, and it turned out that he had $10,000 worth of medical coverage, this MedPay coverage available on his policy. So when we worked with Progressive, they wanted proof of residency, so we needed to provide 2 forms of proof of residency. So we weren't exactly sure what we would have to provide because he was kind of a freeloader. He wasn't really paying rent. He didn't have any utilities in his name. But he had changed his driver's license over to Alabama when he first moved down, and he had a cell phone bill that was coming to this address. So that was our documentation to show residency. We provided it to Progressive. They set up the claim and gave us the claim number and where to submit the medical bills to. Now, we also were investigating to see what insurance was on the school board, and it turned out that the Lee County Board of Education did carry insurance through Alpha that had a $10,000 medical payments policy and a $1 million liability policy, and the bus driver was found to have been responsible for the accident. So that meant that all 5 of these boys had $20,000 of medical payments coverage available to them before we even considered the liability claim. So one of the boys had a broken femur, and his initial bill was around $19,000. So when we got ready to submit the claims to Progressive and to Alpha, we found out that when we reached out to the hospital, we found out that they had qualified all 5 boys for Alabama Medicaid, and they had already submitted the claims to Alabama Medicaid. Once you do that and Medicaid makes payment, you no longer have the opportunity to pursue other reimbursement. So they had, out of that $19,000 bill for the one child, Alabama Medicaid paid around $3,200. But what they should have collected, if you remember that between the 2 policies, there was $20,000 available, not only for the child with the broken femur, but for all 5 children, the reimbursement should have been $19,000. And all of the medical bills that were that the other children had incurred could have been covered under that $20,000 limit for each of them. And then if you figured that the other 26 children on the school bus who had been taken for treatment, they all had at least $10,000 in medical coverage from Alpha. in addition to whatever maybe their parents might have had on their own policies. So the lost opportunity for these hospitals was pretty significant just in relationship to this one claim. So I just like to go over that example because it does kind of tie it in together and just shows the value of having, doing that investigation, or at least trying to ask the right questions to see if you can find out if some of this coverage might be available there for your patients. In terms of some of the other types of payers, this medical coverage, there's a form of medical coverage that exists on homeowners and renters policy. So every homeowners and renters policy has some guest medical coverage, which is usually between $2,000 or $5,000. So it's not optional; it's automatically included under those policies. Things like, if the patient slips and falls at someone else's home, someone else's dog knocks the patient down or bites them. Those are some common claim examples we see where we look to homeowners insurance or renters insurance to provide coverage for the medical bills. A lot of the recreational policies, which is insurance on a boat or a RV, a four-wheeler, a snowmobile, there's medical payments coverage and liability coverage on all these insurance policies. The most typical amount of medical payments coverage is $10,000. We get a lot of snowmobile claims in our hospitals out west, and usually those injuries, I guess those things go pretty fast, so the bills are usually over $10,000, but we're at least able to collect a $10,000 payment under those snowmobile policies. We do look at travel insurance. This is something that we certainly learned to pay attention to over the years. If you purchase an airline ticket or a train ticket or a vacation package and you're given the option to buy insurance, those insurance policies also have a medical coverage element to them. And so a lot of times it's up to $100,000. If you're traveling outside the United States, we definitely recommend that you purchase travel insurance to assist you in case you become ill or have an accident, wherever you're going. But we have found benefit for those here. So commercial premises liability is another coverage we look at. If someone falls at a place of business or is hurt, but here there has to be negligence on the part of the business. This is not something that they have medical coverage that's going to pay it anyway. I see someone has asked a question about why would the uncle's medical coverage on his auto policy have any responsibility when his vehicle was not involved and he was not the driver. The way the medical payments coverage is set up, it's going to cover resident relatives in any vehicle at any time. So it's going to cover you and your family members, whether you're in your own car or anyone else's. Your medical coverage on your automobile policy will also cover anyone that happens to be riding with you in your vehicle. The reason they set it up this way was because they knew that if someone's riding in the car with me, there's probably a relationship between me and that person. So even if I'm negligent and cause the accident, my friend might not want to make a liability claim against me, but if she's got medical bills she can't pay, then she may not feel like she has an option. So that's kind of why they set it up this way. So it's just one of those things where the property and casualty industry, they would much rather pay medical bills at a set amount than have to pay liability claims. So you have to start adding in pain and suffering and all these other things that don't have a quantifiable, specific amount. So they expand it to resident relatives just kind of to make sure that everyone is covered in that situation. It's in a way, it's kind of a loophole in some regards, but you do have to it has to be a resident relative of the household. It has to be a separate policy. But we run into situations, maybe an elderly parent has moved in with their children. Dad still drives. He still has his insurance that's with Georgia Farm Bureau. The kids have insurance through State Farm, but they're kind of covered under each other's policy. So they did not have to add them to the policy. It's just kind of an automatic coverage under the resident relative clause in those contracts. Here's some examples of recoveries, just some dollar amounts on there that, these are some of the more impressive claims. But this is just to show, and these are not third-party liability collections. These are collections from this medical coverage that's available on these policies. So we had one recently. It was $130,000. That was the total bill charges were paid for, and they were paid for treatment in February that was related to a motor vehicle accident back in 1975. So a patient was treated not only at the one hospital that we managed, but also at another hospital across town. So we were able to share that information so that they could go out and get paid. We had the motorcycle that, the patient wasn't riding the motorcycle. He's working on it while it's on the lift. Remember I said the coverage extends to injuries that occur while you're maintaining a motor vehicle, so that's a situation where that bill was paid by the medical payments coverage. We've had a four-wheeler accident covered under homeowners. There, it has to be on your property and someone other than a resident of the home using it, and there is coverage. Once you get outside your property, you do need recreation insurance. I mentioned the snowmobile accident. We've had some other homeowners type claims. Just a typical car accident, the patient had $100,000 in medical payments coverage, and it paid the bill charges of $83,243. So here's just some examples for things that can be covered under some of these insurances. Okay, to move along with the next one, so one of the other mistakes we see, some hospitals are managing their own lien process. They're filing their hospital liens, or they're securing their letters of protection, but they don't have them in an active follow-up. And so the problem with that is that you really need to know when settlement has occurred. As Kyle mentioned, there's a certain amount of time that you have to try to enforce settlement. On most states, it's 12 months, but in some, it's only 6 months from the date of the settlement. So that means if you've got your lien in place and the patient's attorney just ignores it and they give all the money to the patient, you only have that window of time to then go and try to force payment of that lien, through a litigation process. So it's something that, if you're not prepared to do it, it kind of takes away, the value of filing your liens, kind of to begin with. So it is important that you do the follow-up. I know we were implementing a hospital that had always filed their own liens, and when they turned over their inventory to us, some of the liens went back to for 7 years. So we asked them, we said, well, have you had a problem with attorneys just not paying your liens or ignoring them? And they really weren't even aware that that was a possibility. And when we went in and started to work those accounts, we found that most of them had settled years ago and they were no longer viable, and we couldn't obtain any payment for them on that. So you do need to have a follow-up process around your liens or your letters of protection. You also want to know if the patient has lost interest and is no longer pursuing any type of settlement, you want to go ahead and turn that over to patient responsibility, because you don't need to kind of continue to manage it as if you have a lien on there. It's hard to make the settlement process occur any faster. We've experimented with a lot of different ways to see if we could make them settle these cases, more quickly. Probably the most effective way is to involve the patient. You need to do follow-up calls and do a regular checkpoint on the patient just to ask for a status of their settlement process, because then sometimes that'll result in the patient calling their attorney, and that's one way to kind of nudge the settlement process along a little bit faster. We do recommend that you classify these accounts in your system so you know which ones have your liens or your letter protections on them, because you don't want them to automatically time out to one of your bad debt vendors. And you also want to be able to maybe answer questions that your CFO may be giving you about your aging. And you want to say, well, this agency code, those are my hospital liens, so those are going to take longer, but they're going to yield, a good recovery once they do settle. So those are just some recommendations we make that kind of tie into your follow-ups. The next area is just we run into situations where the program's not effective because the hospital has unreasonable negotiation expectations. Some hospitals, we talk to them or the person that's managing the program, and they just feel like, well, we provided the services when the patient needed it, and, why should we cut our bill down to pennies on the dollar? We know that's a difficult decision, but if you can't work it out and negotiate it, between you and the attorney, and if you reach an impasse, it's usually going to end up in some type of legal action. Either they'll just decide to ignore the lien and pay over it, and then you're going to be coming back and trying to enforce it later, or they may file it with the judge in the form of an interpleader and tell the judge he needs to divide up the funds. In that situation, you no longer have any control over the outcome. But we get a lot of questions from when we do this presentation about how do you know what the right amount is to accept in a settlement. We just recommend, there's really no magic formula. We encourage you to evaluate each case on its own merits. You want to ask for and verify the settlement information. How much coverage is available? What are those liability limits? Does the patient have other medical expenses, or have they been out of work for a long time, or are there other medical providers? Do they have liens filed as well? What's the patient's condition and recovery? What's the attorney doing with his fees? Is he expecting a full 33 or 40% for his contract, or is he negotiating and reducing his fees as well? The other thing that we always recommend is don't assume the patient's attorney has exhausted all avenues of payment. You may be dealing with the patient may have an attorney that's relatively, inexperienced when it comes to personal injury cases. They may have missed the fact that there was med pay available. They may not have picked up, maybe their patient had other health insurance and they didn't insist that they file those claims with them or provide that information back to the hospital. Maybe there's underinsured motorist coverage or even an umbrella coverage that could provide additional liability coverage for the settlement. The one thing that we see that they miss most often is you've got the at-fault driver is driving someone else's car. So there should be liability coverage available from both the car and the driver when they're different. So that's one that gets missed quite frequently. So you do want to make sure that we know when they tell you the liability limits are $25,000, that's all there is, that they're not missing some other type of coverage that may be available out there. And our other, we always say, is it reasonable? If you wanted to read the facts of the settlement, as a headline in your local newspaper, would it reflect well in the hospital? If you've got a catastrophic injury and the patient is no longer going to be able to work, or they're going to be out of work for a long time, and you've got a six-figure medical bill, to insist on a third of the $25,000 liability coverage, may not be the best recourse for you. Maybe having them apply for the charity care could be something that you do in exchange for releasing your lien. So, you just want to look at it from that standpoint. That's just always our recommendation, is that you kind of look at the big picture and consider those options. The next thing we see is that sometimes the programs that are in place are only in place there for high balance accounts. Well, you usually have less opportunity for payment under high balance account than you do for other accounts, because when you've got a really large bill, if you're going to just file a lien on those, there's probably other medical expenses as well that are going to have to be paid out of the settlement proceeds, or maybe other medical liens as well. The patient injury might, is often disabling, so you've got large claims for wage loss that may be coming into play. When you consider that, liability limits are usually only about $25,000, sometimes less, there's not a lot of money to be distributed between the attorney and the patient and satisfaction of the medical bills. But these smaller balance accounts are often going to be paid in full, and you usually have a lot more $2,000 to $5,000 accounts in your revenue cycle than you do six-figure accounts. So we recommend, instead of just concentrating on a high balance of lien, for liens, that you kind of have a good process that you're applying, across, including a lot of the smaller balances as well, because I think you'll get a much better recovery in total than just looking at high dollar accounts. So the next area just to touch on is a mistake, and this is one that can be very costly. So we have always been very conservative in our approach to third-party liability recoveries and making sure that, and we have never advocated for filing a third-party liability lien when there is commercial insurance available to the patient. And if you get motivated by the higher reimbursement that you can get from PPL coverage than what you sometimes see even in a commercial contract, you can kind of go down this path and you can end up with a bad result. You could end up with class action litigation. You can, cause some unfavorable changes in your hospital lien statutes. And quite often your collection percentage could be lower than if you had just filed it with the commercial health to begin with, because sometimes there's not a lot of coverage to go around, as I've mentioned, previously. And you also have the impact on your AR days. So those are just things that, we just strongly recommend against trying to get the third-party liability instead of filing commercial health insurance. And you need to be careful, too, when you're looking at, your governmental payers, because, CMS guidelines are very clear. They actually encourage you to pursue, and you have the option to go after third-party liability instead of filing with Medicare. They just say you can't do both. But you want to look at that and make sure that you're not getting a better reimbursement from filing with Medicare, Medicaid than what you might be looking at for third-party liability situations. And you need to, if you've got a Medicare HMO, it's a lot of that contractual language and specifics, the hold harmless provisions that are going to create problems for you and could open yourself up to some risk to these class action litigations. So we definitely recommend a conservative approach. You really want to stay on top of not only how your statutes are interpreted and your contract language, but also how maybe case law that's going through your own state may be interpreting those statutes, and also kind of what the trends are across the country. So on that note, I'm going to turn it back over to Kyle, and he's going to touch on some of the things that you want to look at in your hospital lien statutes and some of these trends that we're seeing across the country.
Thank you, Lori. Go to the next slide. I want to talk about what generally is included in hospital lien statutes and some of the very specific components that often differ among states. Generally, hospital lien statutes include the amount recoverable. They may describe this as reasonable or usual and customary charges. That's the amount that a lot of times the personal injury attorneys try to cram down by saying that the hospital's charge master is not reasonable or usual or customary. Typically, there's a notice requirement. You got to let the at-fault driver know that you're filing a lien, the at-fault driver's insurer, and usually the patient as well. Typically, there's a filing requirement, so you can file it with the clerk of court. So insurance companies or the PI attorney can call the court or go online and search for a hospital lien. There's always, because attorneys typically become legislators who like to take care of attorneys, typically your attorney's fees are priority. They get paid before the hospital lien. Typically, there's a right of enforcement. Allows the hospital to sue the at-fault party's carrier, sometimes a UM carrier, to enforce the lien if they don't protect the hospital when paying off the settlement. And finally, there's typically a statute of limitations that provides an amount of time where a hospital can sue a liability carrier or an insured motorist carrier to enforce its lien. Typically, that's 6 months to a year. Now, some of the very specific issues among states, Lori touched on that. I'm going to touch on some cases. There's a prohibition on lien filing when the patient has other health insurance. It's a trend that we're seeing. There's a limitation on amounts recoverable. For instance, California, a hospital can only recover 50% of all amounts remaining after the liens have been paid. Typically, with a $15,000 policy, you chop off the $5,000 for attorney's fees, and you're left with 50% of the remaining $10,000. Not a whole lot of money there. There's a timely filing requirement. Sometimes those are strictly enforced, like in Georgia. You got 75 days to file a lien. If you don't hit that, you can't sue the insurer. Some states like Alabama have safe harbor provisions that provide that as long as the patient and the insurer and the at-fault party receive notice prior to the date of settlement, then that timely filing is just kind of a recommendation. Lien's still enforceable. Sometimes you have broader provisions that allow for your physicians groups or ambulance drivers or even chiropractors to file liens. Sometimes the lien statute might require the hospital to cancel the lien when it's satisfied, and they might be subjected to a penalty for failing to cancel, and they have to cancel it at the hospital's expense. There could be requirements that the hospital provide records within a specified period of time, otherwise the lien will be invalidated. So if you have a third-party vendor who is providing medical records to patients, then you need to work with them to make sure that you hit those time periods. Finally, there are provisions that permit patients to contest reasonableness of charges before filing suit. So these are all very specific issues. A lot of states don't currently have hospital lien statutes. There's about 9 of them, but you still should bill first-party medical. You should still make an attempt to bill third-party liability or obtain a letter of protection. So let's talk about some of the trends. There's a trend with statutes that many states have amended their hospital lien statutes to require that hospitals bill commercial health insurance. I want to point out Colorado in 2016, Colorado senator's child was injured in a motor vehicle accident, taken to a Colorado hospital, where that hospital leaned up the charges to collect a higher amount than what the child's commercial health insurance policy would have paid. The senator called, immediately submitted a bill to prevent this. What it did was it created a penalty, twice the amount of the lien. If a Colorado hospital knowingly files a lien, instead of billing the patient's commercial health, they could be responsible for paying twice the amount of the lien asserted. And even more important, the lien amendment created a kind of a contradiction with regards to whether or not a Colorado hospital could file a lien when the patient has Medicaid, is a Medicaid recipient or a Medicare recipient. There was two cases that hold opposite in Colorado Court of Appeals that the Colorado Supreme Court will have to decide, but they did put in there that, you know, if there's a third-party payer, that could include Colorado Medicaid, that they have to bill Colorado Medicaid, which you don't have to do in any other states. Discovery rules, there are 3 states that require hospitals to disclose their other payer rates. Those states include Indiana, Georgia, and Texas. And finally, the recent class actions, there's 2 types. There's one where the plaintiff's attorney just accuses hospital of fraud for merely filing a lien at charge master rates. 2 states where these class actions have occurred is Georgia and Texas. In Georgia, the seminal case is Bowden versus the Medical Center that started off as a discovery case, which created the discovery rules in Georgia. But the plaintiff's attorney said that the hospital committed fraud by filing a lien at charge master rates, as did the plaintiff's attorneys in Texas. In Georgia, they determined that as a matter of law, a hospital does not commit fraud by filing a lien at charge master rates. So the Georgia Supreme Court really had hospitals' backs in coming down with that decision, and there were 14 pending class action lawsuits as of May 20th, and all of those went away with that great Bowden decision. So that was great news for us in Georgia. In Texas, they set up multi-district litigation as a matter of law. That the question answered in Bowden has not been answered in Texas. So it's very important, if you're a Texas hospital, you need to seek legal advice when filing hospital liens. Finally, I just listed a few class actions where the hospital was accused of fraud for filing liens in lieu of billing commercial health insurance. We have Texas, Arkansas, Alabama. None of these cases have made the decision that the hospital had committed wrongdoing. A lot of times these plaintiff attorneys will make a bunch of allegations and not understand the internal processes. They assume the worst about hospitals. So, for instance, Balderus, the vendor that was in that case, was dismissed and is no longer a party to that class action. And I think that a lot of times plaintiff's attorneys get it wrong. But you can see in Arkansas, Whitley versus Baptist Health, that class was actually certified. So that is further along in the litigation. And the major point we want to hit on is, if you're doing that, not only are you going to have to wait for payment, but even if you do see a lift in revenue later on down the road, when some plaintiff attorney gets wind of this, that lift can be eaten away by your attorney's fees.
Right. So, and we're not saying that because we want to make, scare anyone. It's just, it's definitely good to have a program for your MDA and TPL collections. We've talked about the benefits, not just to the provider, but the patient. But you just want to make sure that you are staying compliant and that you're maybe being conservative in your approach to it. And whether you're doing it yourself or you've engaged with a partner to manage this for you, you just want to make sure that they're really protecting your best interests and that they've got processes set up. I know, and it's not always your vendor that may be pushing you to do it. We have dealt with hospitals which really wanted, you get lured by that higher reimbursement. But again, most of these issues come when you're trying to pursue TPL recoveries instead of filing the commercial health, for the contractual rates that you have available there to the patient. So I know we're right up against the time. I wish we'd had more time. I saw some questions. We tried to answer a few of them as we went, but our contact information, email is here. I'm happy to try to answer any questions if anyone wants to shoot me an email, or Kyle as well. But we really appreciate your time today, and we wish you good luck and great recoveries on this segment of your revenue. Thank you.
Great, thank you. On behalf of AAHAM, thank you everyone for joining today's webinar. And also a big thank you to Lori and Kyle for an excellent presentation. I'd now like to direct your attention to the survey that I have just brought up to your screen. If everyone could take a moment to fill out this brief survey, AAHAM does appreciate your feedback. This concludes today's session. To end, you may simply hang up. Have a great day.